So hello everybody, welcome to the Swiss Patent Litigation Fireside Chat. It's already the 37th edition, the last Wednesday of a month, this time April. Spring is starting off. Glad you made it to this session. I shared the agenda up front on quite short notice, admittedly only yesterday, and I will pretty much stick to that agenda with some minor additions. As always, if you have any questions, comments, please leave me a line directly in the comments section. I will have an eye on that. So if I manage to, I will directly pick it up and address it, or otherwise just leave me a comment after the session. I'm always happy to discuss what I've presented in these fireside chats. So let's directly dive in. Hold on a second. I need to switch that back. So here we go. That's the first case that I wanted to briefly discuss. That's, I call it on the blog, the never-ending story. That is a case that has popped up already 3 times. So the first hearing in that case was on the 12th of June. Then it was continued on the 6th of November last year already. And then I had already a feeling that the parties were close to a settlement, but obviously I was wrong. There was yet another hearing on the 3rd and the 4th of April this year. And again, witnesses have been heard. So what that case all about, that's litigation between Imholz GmbH and Emil Giesler. And that's a classic ownership dispute, an assignment action. So the owner of the plaintiff, Pius Imholz, requests that a patent of Emil Giesler be assigned to him. He was employed by Emil Giesler, but it is asserted that this was not a service invention, so it was an invention that belonged to the inventor. And there are 2 case numbers. The one is for the action of Imholz GmbH, and the counter action is if this patent application were to be assigned to the plaintiff, then there is a financial claim by Emil Giesler for the costs that were involved in patent drafting. So that's pretty much the background of that story. I only attended the hearing on the 3rd of April. It was continued on the 4th of April with yet further witnesses. So the witnesses were all sales representatives of Emil Giesler, and it was obviously a chance for the court to, well, get a first-hand impression of what these sales representatives were expected to do or not to be expected to do under their contract, their employment contract with the defendant here. I've already commented in depth on the blog, so it was not, well, I did not learn much in that hearing. It was typical answers of sales representatives. They of course try to solve the issues that the customers have. It's not always standard equipment that was sold. There are adjustments to be made. We need to see how that plays out in the end. Since there was nothing published yet officially by the court concerning the representatives, so the plaintiff is represented by Fura Marbach, specifically serial reader, and Emil Giesler, the defendant, is represented by Simon Holzer and Andrea Heiniger from MLL Legal. So yeah, that's obviously a pretty intense case. The parties lock jaws heavily. So yeah, we need to see when the judgment will be issued. There was no specific date mentioned for that. As always, as soon as possible. That's what I took from the hearing. So moving on to the next case, I need to make a disclaimer notice, a disclosure notice up front. Our firm was involved in that case on behalf of the plaintiff. So I will be pretty brief on the merits here. That was litigation between Framliner and Berna Tresor. The subject matter at stake, you can get an idea of the subject matter from the figure on the right side here on the slide. That is a kind of protection device for cash machines, for ATMs. And it was about a security feature for these shields for ATMs. And yeah, bottom line of the judgment was that the PI that was requested by Framliner was denied because it was not rendered credible that a feature was fulfilled that was necessary in the claim, and the defendant had denied that this feature was indeed fulfilled, and that was the reason why the PI was dismissed. So the whole judgment only dealt with infringement, not at all with validity. The interesting part in that judgment, maybe as an interesting part for the broader audience, was the redaction of the judgment. That's just one piece of the judgment. The heading here says fulfillment of feature, and then the redaction, so it did not spell out which feature was at stake here. That was in the end held to be not fulfilled, or not made credible that it was fulfilled. But what was clear from the non-redacted part was that the feature concerned security systems. And even though my firm was involved in that matter, I was not directly involved, and I just took the judgment as it was. And well, when you read that in one go, it's pretty clear that a feature was at stake that pertained to security systems. And yeah, guess what? There is only one feature, namely feature 6, in the claim that specifically concerned security systems. So even from the redacted judgment, it was abundantly clear that this feature was at stake, meaning it was not credible that this was fulfilled, and defendant denied that this feature was indeed fulfilled. So the PI request was dismissed for this reason. So later, I discussed the case with the colleagues in my firm that were involved in that matter, and I had the chance to take a closer look at the procedural order that dealt with the extent of the redaction of the judgment and the reasons of the court why redaction of the judgment was indeed allowed. And I made a separate post on the blog on this issue only, because the longer I thought it through, the less I understood it actually. So, and I put a quotation from this reason of the procedural order here on the slide. One requirement for a redaction of a judgment, because it contained manufacturing or trade secrets of a party, one criterion, therefore, is that information that is concerned there is not overt, offenkundig in German. And when is information not overt? As long as it is possible for the owner of the secret to control the dissemination of the information. And what happened in that case is from the very beginning of the litigation, so with the first brief, defendant requested that the judgment be only published in redacted form, and yeah, that was what was in the end then discussed and decided and allowed. But apart from that, defendant did not take any measures to prevent the information from further dissemination. And two examples, what could have been done by defendant was, first, it was not even tried to hide this information from the plaintiff. So the plaintiff had all the information that was in the end redacted in the judgment simply from the briefs of the defendant. There were no measures taken to have this information disclosed only for attorney's eyes only, for instance. And second, the hearing at the Federal Patent Court was public, and there were two visitors from the public. It wasn't me, but there were reportedly two visitors, and the parties have obviously no idea who that actually was. So, in my opinion, but who am I? The owner of the secret lost control of the dissemination of the information, because a competitor that has sued him actually for patent infringement is obviously free to use that information. The plaintiff has no confidentiality obligation whatsoever. And the visitors who heard the information at the hearing, no one has any clue what they are currently doing with that information. So I think that the order that actually allowed redaction of the judgment was on the very forgiving side. But if you have a different take on that, I published the order in voluntarily redacted form on the blog, and you will find my complete reasoning on the blog. I would be very happy if one of the attorneys at law would educate me when I'm wrong. But yeah, I would like to hear what you are thinking about that. I'm not perfectly in agreement with that order. Yet another interesting part of that case was the costs or expenses for the patent attorney. So as you will quite likely be aware, the patent attorneys are not refunded according to a specific tariff, but patent attorney work is dealt with as necessary expenses that have to be evidenced in order to be refunded afterwards. And typically, the costs or expenses that have been incurred for a patent attorney should be in about the same range as the costs that are refunded for legal representation according to the tariff. And here, the cost for legal representation according to the tariff that were awarded were 23,000 Swiss francs. And then the question was whether the costs for the patent attorney were also to be refunded, and to what extent. So defendant incurred costs of 147,000 Swiss francs, and defendant submitted a cost note to that extent. And the plaintiff objected to that cost note because it was not substantiated to sufficient extent. And interestingly, the judgment says, yes, the cost note indeed is not substantiated to that extent. And I take from the wording that it was meant, it was not that the cost note was not substantiated at all, but not substantiated to the specific amount. So by way of comparison, plaintiff had incurred costs of 62,000 Swiss francs. And the judgment then holds, yes, it was not sufficiently substantiated that 147,000 Swiss francs were incurred. And nevertheless, 23,000 Swiss francs were awarded, even though the judgment holds it was not sufficiently substantiated. And the 23,000 that were awarded are exactly the same amount that were awarded for legal representation according to the tariff. So bottom line here is, I think as long as it is pretty clear that the cost note is too high, but that a patent attorney was obviously involved to quite significant extent, and I would say when infringement and validity is at stake and discussed in the briefs, it's pretty clear that a patent attorney indeed was involved. You might still have a chance to get at least the comparable costs for legal representation also awarded for the patent attorney. But still, preferable would of course be if the cost node were sufficiently substantiated by itself. So I would not be so bold to take that as a kind of carte blanche to just assume you will get the same amount as the lawyer involved. So moving on to the next case, this is litigation concerning lisdexamfetamine. I've drawn the molecular formula on the slide here. That's a hearing that is not yet discussed on the blog. I have a draft ready. A colleague visited the hearing and briefed me on that, but I did not yet manage to put it on the blog. So attorneys involved here for the defendant, so it's a nullity case. The patentee defendant is Takeda, represented by MLL Legal, Simon Holzer, and Ulrike Ziesler as a patent attorney. And the plaintiff, the nullity plaintiff, is Spirik, represented by Wrench and partner as an attorney at law, Christian Hilty, and Andrea Carrera, assisting as a patent attorney. So, yeah, that's a case. Lisdexamfetamine, you might already guess it from the name. That's an amphetamine, and amphetamines are notoriously prone to potential abuse because it has a pretty quick euphoric effect. So abuse is a higher risk. So lisdexamfetamine, you can see that on that slide here. Lisdexamfetamine is, well, kind of a prodrug. I think it's simply a prodrug. It's split in the body and only then sets free dexamphetamine, which is an amphetamine, and lysine, which is not active. So by this mechanism, the effect is kind of delayed or has a reduced onset. So this counters the risk of abuse. That's pretty much the effect of lisdexamfetamine compared to dexamphetamine. So moving on to the next slide, here you can see the package of the defendant's product. So plaintiff, the nullity plaintiff, Spirik, is already on the market with this product that you can see here. From the hearing of the 9th of April, it became pretty clear that the technical opinion of the judge rapporteur was favorable for Takeda. So the preliminary opinion was that the subject matter claimed was indeed inventive. So, which brings me then to the next case. With that in mind, obviously, the PI proceeding is running in parallel. This time initiated by Takeda as a plaintiff against the same party, Spirik. And interesting there is that in the nullity case that we have just looked at before, in that case, there was no discussion at all whether the SPC might have an issue because it is not the first market authorization was used as the basis for that SPC. That was not discussed at all in the main nullity proceedings, but obviously that is discussed in the PI proceedings because the announcement of the hearing, which is scheduled for the 21st of May, this announcement specifically mentions that the defendant here asserts that the SPC should not have been granted because the market authorization for Takeda's drug Elvanzi is not the first market authorization for the active ingredient lisdexamfetamine. Again, as a reminder, we have just looked at that slide here. That discussion pertains to the question, well, if lisdexamfetamine is only kind of a prodrug and dexamphetamine is the really active ingredient in the body, is then L1C that uses lisdexamfetamine, is that really the first market authorization for the active ingredient, or is the first market authorization for the active ingredient market authorization for dexamphetamine on the right side? So that is obviously a discussion that we have in the PI proceedings in Switzerland. Interestingly, the same argument has also been made in other countries elsewhere. And in Germany, the SPC has indeed been revoked for that reason, while I came across a judgment in Sweden where, based on the same European SPC regulation, the patent was, the SPC, I'm sorry, the SPC was held valid. So that will be interesting to see how that plays out in Switzerland. Well, I could come up with an educated guess here, but I won't. So let's see how that plays out in Switzerland. Yeah. So this hearing has been announced for the 21st of May, and that would definitely be interesting to join that hearing in order to get an idea of what the judge rapporteur thought about that SPC argument. If I have a chance, I will definitely go there. The next case is again a case where our firm is also involved. That is a joint PI proceedings where actually 3 proceedings have been joined. Biogen had requested a PI against Sandoz, Viatris, and MEFA. Our involvement here is for MEFA. And this case concerns dimethyl fumarate. That is a drug for treatment of multiple sclerosis. And here are the representatives again, because there is, it is already on the blog, but nevertheless. So Biogen is represented by MLL Legal. Louisa Galbraith held the main part of the pleadings, and Simon Holzer and Ulrike Ziesler as a patent attorney. And Sandoz is represented by Andre Hess of Hamburger, Viatris by Terry Callum and Barbara Abeck, assisted by Siegfried Grimm from Bloom. And MEFA is represented by Andrea Mondini, assisted by Andrea as well from our firm. So in that hearing, it was clear that the judge rapporteur's opinion was, well, bottom line, the patent was held to be invalid. A lot of reasons were asserted by the defendants. Insufficiency of disclosure, unallowable amendments, obviousness. At least in terms of obviousness, the judge rapporteur followed the arguments by the defendants, not so with the other reasons. As always, we need to see how that plays out in the final judgment. Interestingly, of course, when you have joint proceedings with 3 parties on one side, that's quite a crowd in the courtroom, and it's not so easy to align the statements and then join it to one pleading, actually, because that was what was agreed with the court in a phone conference up front, that the court obviously did not want to hear 3 times pretty much the same arguments, but that the defendants make one pleading. And the president made it clear up front that this one pleading that was held by the defendants, that all 3 defendants would be bound by what has been said in that pleading if the other defendants would not immediately jump in and say, oh, that was not on behalf of me, I don't agree with that, which did not happen, by the way, of course. In the end of the hearing, there was again an interesting discussion about costs, and again for the patent attorney, costs involved. And Thierry Callum made an interesting remark about the joining of the proceedings and what implications that had for the actual efforts on behalf of the defendants, because joining proceedings might make it easier for the court in a way, because they only need to hold one oral proceedings, not three. But defendants obviously have to very thoroughly align their positions, which actually increased the efforts on the sides of the defendants, which should be reflected by the costs, not only for the patent attorneys, but also for the legal representations. Defendants argued that the refund according to the tariff should be fixed on the very upper end of the tariff. And there was quite a lively discussion about the costs later. Needs to be seen when the judgment will be issued. As always, the court mentioned as soon as possible, whatever that means. So, which brings me to a decision from the EPO, not from the Federal Patent Court in Switzerland. It's a decision of the Judicial Board of Appeal of the EPO that I had addressed already quite a few months ago. It is still a highly or very, very intensely discussed topic for a simple reason. The head notes, which you can see on the right side here, they are pretty controversial, I would say. So they put in question the parties' rights to oral proceedings. And I think it's important to understand the background here. So the case pertained to a restitution, so Article 122. And as you all know, you need to make your full case when you request restitution, and you can't back up your assertions later. But still, you should have a chance to present your arguments based on the facts that you have submitted in due time in oral proceedings. But here, the Judicial Board of Appeal said, no, you don't have an absolute right to oral proceedings when the case, the facts are so clear that you have no chance anyway. There is no absolute right to oral proceedings. And in such cases, oral proceedings do not serve any legitimate purpose. And then the requirement of legal certainty in due time not only leaves the board the possibility to not hold oral proceedings, but here in the head note 4, it says this requirement of legal certainty in due time prevents the board from appointing them, which is a very strict consequence of not serving any legitimate purpose, and that obviously gives boards quite some leeway to determine by themselves, is there still a legitimate purpose or not? Oh, if there is no, then we just decide based on the facts on the case in writing. That has been controversially discussed, and even other boards have noticed and addressed this decision. Meanwhile, there are 5 decisions that have cited this J decision. Meanwhile, 2 technical boards of appeal have explicitly disagreed with this approach. But the most recent one is, again, a restitution case that has used the exact same wording of the head notes. So there is obviously a dissent, meanwhile, amongst the boards, whether this is the right approach or not. Interestingly, this J decision has also been further prosecuted to the enlarged Board of Appeal in a review procedure. That's R16 of 23. Hearing there is scheduled for the 21st of November this year. And I've learned that EPI sent a letter to the enlarged board and encourages the enlarged board to invite the public to submit amicus curiae briefs in this case, which is pretty unusual that amicus curiae briefs are invited for review procedures. But I think if there has ever been a case where this makes sense, then this is it. Because obviously that J decision already triggered controversial opinions amongst the technical boards. And if now in a review procedure, the enlarged Board of Appeal takes a position on that, this would resolve that issue one or the other way. And I think if the enlarged Board of Appeal decides on such a controversial issue that already raised different opinion amongst the boards, then this should not be decided without inviting amicus curiae briefs on that issue. So I hope the enlarged Board of Appeal follows that request, but yeah, we need to see. So if you're interested in that case, you can find it easily. You just use the advanced search on the EPO register, search for that J number, J000622, then it will directly lead you to the docket to watch. If you don't find it, just drop me a line. I will be happy to send it. Finally, that is a case that is neither Federal Patent Court nor EPO. It's just my case that I have with the Federal Administrative Court. I mentioned that a long while ago. That is a case where I requested the file wrapper from the IPI, the Swiss Patent Office, for an SPC that had been rejected by the Patent Office, and that rejection had then been appealed to the Administrative Court and further up to the Supreme Court. And I requested the file wrapper, including the submissions of the parties before the Administrative Court and the Supreme Court. Yeah, I knew I was pushing the envelope, and I only got the files up to the rejection by the Patent Office. And yeah, I did not like that decision, and I appealed that refusal to give me the whole file wrapper to the Administrative Court. That was back in March 23, I think. So quite a while ago. I almost forgot about that case. I remembered a few weeks ago, and 2 weeks ago, then I took the liberty to ask the Federal Administrative Court for a status of that appeal, because I felt it would be much appreciated by practitioners if that judgment and the considerations of the Administrative Court on the access to the file wrapper for appeal proceedings, that this would be helpful for the current revision of the patent ordinance that are upon to go into public consultation end of this month, and the consultation will run till end of August, I think, if everything works out as planned. So it would have been good if that judgment would be out in order to consider it in this current revision cycle. But I heard back from the Administrative Court that, well, good and bad news, obviously. So first draft of the judgment will be discussed still in the first half of this year, but they have no specific information when I might expect the judgment. So yeah, we shall see, as always. So that was it from my side. I'm just looking at the comments section on LinkedIn, whether I missed anything. No, apparently there is no comment on LinkedIn. Anyway, if you have any questions or comments later on, please just drop me a line, and I will be happy to discuss or answer any question or concerns that you might have. Otherwise, I'm finished with this session. Thanks for joining again, and I hope I will see you again end of next month, last Wednesday of May then. Take care and bye-bye.